Well, welcome everyone to Steve Savant's Money, the name of the game. I'm your host, Steve Savant, syndicated financial columnist and money color commentator. On today's show, myths about handling assets, part one of our series on estate planning with estate planning attorney, Elizabeth Westby. Welcome to the show, Elizabeth.
Thank you, Steve. Thanks for having me.
I should say welcome back.
Yes, this is my second time.
I mean, when I go out to the internet, I see package sale, wills, trusts, revocable, irrevocable, package $2.99, you're out the door, do-it-yourselfers. I have found in my practice of 35 years, you cannot do it yourself. You cannot.
That's probably true, mostly true.
Mm-hmm.
I would say some attorneys could probably handle it themselves, but for the average individual, I wouldn't do it. I always recommend going to a professional. But along those lines, there are some misconceptions or myths, I would say, that the consumer has.
Well, give me a big one.
All right. The first one is people think, well, if I don't have a proper estate plan, then the state will take all of my money. That's not true necessarily. There's a very small percent of a chance that that could happen. But if you fail to create a proper estate plan for yourself and for your family, the state creates one for you. That is what is called the intestacy laws. And every state has their own intestacy laws. In Arizona, that pass, or your state would pass in what is called per stirpes. So that really in a basic form means if you're married, it's going to your spouse. If your spouse is deceased or you don't have one, it's going to your children. If you don't have any children, then it goes up to your parents and then down to your siblings and so forth. So it's just a manner of how the state determines that your assets will pass.
Does it matter? And there's several states like Arizona. Does it matter? Because I have people say, hey, it's a common, not common law, what's the word I'm looking for?
Misconception?
No, it's a common misconception that everything, because we're living in a state, that everything passes to the person anyways. Well, why do you need the estate planning period?
Well, that's the worst part, is that so many people have combined families now that perhaps you have children from a prior marriage. And if you were married, let's say, for example, then everything, if you didn't have an estate plan, would pass directly to your wife and then effectively disinherit your children. That could be very sticky. That could be very messy for your loved ones. And particularly if you have people who depend on you and rely on you and maybe aren't related to you by blood, you certainly want to name them and have them provided for in your plan.
Well, I'm worried about all the misconceptions. Here's a big one. Well, I have a business. I'm a small business person. Remember, America's composite corporate life is 70% small business people.
Yeah.
And I have an LLC. Why isn't that enough?
Well, everyone thinks I have an LLC, so I'm protected. And they even think that they can go online themselves, create this LLC, and just because they've created it by themselves, that it's doing everything that it's supposed to do for them. An LLC stands for a limited liability company. That means that it's supposed to prevent or protect your personal assets or your personal liability. The problem that we find in the business is that perhaps there's a formation issue. Maybe the articles of organization were not properly filed with the Arizona Corporation Commission. Again, these are state laws specific. So if you're in a different state other than Arizona, this may not apply to you. But in Arizona, that's how it works. Perhaps there's formality issues. It is so easy to follow the formalities and have this LLC protect you the way it's intended to. But many people, for example, don't enter their annual meeting minutes. They don't follow the bylaws and those kinds of things. So if you're not able to demonstrate, and that's what it's all supposed to be doing, is demonstrating that the LLC is a complete separate entity than from yourself, then you're running into problems. So separate entity, what do we want to do? We want to file our tax returns and have a professional do that for us, just so that we know everything is separate. If you're supposed to be taking payroll, make sure you're taking payroll, not just transferring money from your business account to your personal account. Definitely, I would have everything reviewed. If you are even questioning whether or not you've set up your LLC properly, or you're like, wow, for the last 3 years, I haven't filed my meeting minutes, well, then maybe have a professional look at that, whether that be an attorney or a CPA or a combination of both, and just check up on the formation and the formalities.
In a community property state like Arizona, I think there's another misconception. Hey, because we're in a community property, my spouse is going to get it anyways. Is this another area where we make mistakes? We just kind of default to whatever the state has on the books?
Yeah, I think that this is another area as far as the community property is concerned. Again, there's a couple of issues. Back in the day, I would say it didn't really matter. Community property, of course, you would probably want to share all of that with your wife because you're probably going to stay married. But as we get married older, which is tending to happen nowadays. You were just telling me about your daughter.
Right.
She's very successful, right?
Right.
But she's unmarried yet.
Right.
And that's what's happening. So she probably has a little something to protect at this stage in the game.
Oh, yeah.
But you and your wife got married, what, you were 18, 20?
Well, we were back there.
Exactly. So you were building your lives together. There's a difference. And the likelihood of getting divorced now, let me tell you, the average divorcee now is 50 years old. So wouldn't that be beneficial to be able to keep the sole and separate property yours as opposed to having everything in the community considered a marital asset?
So you can make, even in a community property state, you can make designation on what ownership is, what entities you can use, what trust documents. Elizabeth, what is this thing called quitclaim? I thought it was a good thing.
Well, it certainly can be, but of course, with anything else in the law, you have to be very, very careful. A lot of times people transfer property with a quitclaim thinking, well, sure, I just want to transfer it to my sister or my relatives. And that's really the basis is folks want to keep a piece of property in the family for years because property is valuable and oftentimes the most value that we have among our assets. The problem with this, however, is when you quitclaim a property using a quitclaim deed, you're transferring everything that was under that title along with that deed. Meaning that there could be dirty title, or how you referred to it earlier was a clouded title. Yeah. And really what a clouded title is, any irregularity in the chain of title, which renders that unmarketable. Why do we care about that? Because then we can't sell it. We can't transfer it.
So do you have to look at the historicity behind this to make sure everything's kind of up to stuff and it was transferred equally?
That's exactly where I was going.
Wow.
And that's the problem. So usually the last man or woman holding the title doesn't realize it until they're coming in, trying to get a mortgage on the house, for example. I have a quick story for you. I had a client come in to see me.
By the way, before she starts, just remember, every time I bring Elizabeth on, whatever we talk about in the law, there's always a horror story.
There is, because this is what I see, and this is what sticks in my mind, and I think it'll help people relate to this and help them remember. So, client comes into my office. She has a quitclaim deed that had been signed over by a woman, the owner of the property. Well, sure enough, she tried to get a mortgage on the home, to do some repairs on the home, and she couldn't do it. They wouldn't give her title insurance for it. So she says, well, what the heck can I do about this? I said, well, let's look into the history of the property. Sure enough, husband and wife had both owned the property together. Now, remember those community property laws. Both partners were equal owners of that property. So the wife couldn't just sign her half over to the client, correct? They needed the husband's signature. So we say, well, we need to go get the husband's signature. One problem, he's been dead for 40 years. So what do you do then? Well, then a small problem becomes a huge problem. We're looking at quiet title lawsuit. We're looking at opening a probate because, of course, he didn't have a proper estate plan in place. And we are looking at finding and serving on notice under the probate laws every single person that he is related to who could take part ownership as an heir at law. Remember, intestacy laws are rulings, so we have to go to probate. So that's how that works. You can imagine it becomes a mess. How many individuals do you have to find and notify of this potential asset just so you can have the court say, yep, you are the owner of this property and we can in fact sign on husband's behalf.
This happen a lot?
Not this exact scenario, but certainly where there is a clouded title and somebody cannot either transfer the property at that point or take out a loan on it.
Wow. Well, listen, don't forget to watch our next episode, Senior Financial Abuse, Part 2 of our series on estate planning. And keep in mind, before moving forward with any of the ideas on our show, always check with your tax consultant, legal counsel, and financial advisor. You've been watching Steve Savant's Money, the name of the game.